Hello and welcome to today's lecture on Law of Civil Marriage. A civil marriage is a special form of marriage which is often termed as court marriage. It is a secular form of marriage solemnized under the Special Marriage Act 1954, which has replaced the Special Marriage Act 1872. This is the first and only secular law of marriage and divorce, which is an example of the steps taken towards the achievement of the goal of Uniform Civil Code as envisaged under Article 44 of the Indian Constitution. It covers both intracommunal as well as intercommunal marriages between the parties because the religion of parties intending to marry is absolutely irrelevant. Number 1. Intracommunal marriage. Two persons who belong to same religious community can marry each other as per their personal laws or under Special Marriage Act as an alternative to their religious personal laws of marriage. Number 2. Inter-communal marriage. A person desires a marital relationship outside his or her religious community. He or she can marry under this act irrespective of any restriction under his or her personal law. Conditions for solemnization of civil marriage, Section 4. Certain conditions are to be fulfilled by the parties to be eligible for the solemnization of civil marriage. These essentials are enumerated under Section 4 of the Special Marriage Act 1954. It lays down, number 1, neither party has a spouse living at the time of marriage. Spouse means husband or wife. Neither party is incapable of giving a valid consent due to unsoundness of mind or is suffering from any mental disorder which renders him or her unfit for two purposes. Number 1, unfit for marriage, and number 2, unfit for procreation of children, or has been suffering from recurrent attacks of insanity. Parties must have completed the required age, that is 21 years for male and 18 years for female. The parties are not within the degrees of prohibited relationship, except if any custom governing any of the parties permits the marriage between them. Such marriage may be solemnized. The degrees of prohibited relationship has been defined under Section 2B of the Act of 1954. Solemnization of marriage in state of Jammu and Kashmir. Civil marriage can be solemnized outside India, but following conditions are essential. Number 1. The parties to the marriage must be the citizen of India and domiciled in the territory to which this act is applicable. That's any territory in India. The civil marriage can't be solemnized between two non-citizens or between a non-citizen and a citizen outside the territory of India. Registration of marriage. The registration of civil marriage is compulsory for a valid solemnization of the special marriage. The validity of marriage is affected by failure to register it. The Hindu Marriage Act 1955, which is in pari materia with the Act of 1954, has a provision for optional registration under Section 8, but not for compulsory registration. In Seema versus Ashwini Kumar, the Supreme Court has issued the directions that the marriages of all persons who are citizens of India belonging to various religions should be made compulsorily registrable in their respective states where the marriage is solemnized. But the Special Marriage Act 1954 itself provides the following procedures for the registration of marriage. Solemnization and registration of marriages under this Act of 1954, Section 4 to 14. Conditions for marriage. Parties intending to solemnize and register their marriage must fulfill the conditions given under Section 4. The intending parties must give a written notice to the marriage officer of the district in which at least one of the parties has resided. The period of residence must be 30 days immediately preceding the notice. Recording in marriage notice book and publication. This procedure is meant for marriage officer after receipt of notice. He will record the contents of notice in prescribed register called marriage notice book. A copy of the notice shall be affixed to some conspicuous place in his office. If the parties are not residing permanently in the local limits of the marriage officer, he shall transmit a copy of notice to the marriage officer under whose jurisdiction the parties are living. Then such marriage officer shall affix a copy at some conspicuous place. Objections to marriage. Any person can file objection against the intending marriage within 30 days from the date of its publication. Objection can be given on the ground that it would contravene the conditions of marriage contained in Section 4. Disposal of objections. The marriage officer shall wait up to 30 days from the date of publication of notice. Then there are two possibilities. Number 1, if no objection is filed, then the marriage may be solemnized. Number 2, when objection is received, the marriage officer shall inquire into the matter within 30 days from the date of objection and arrive at a decision. If the objection comes out to be unreasonable, vague, and prima facie untenable, then the marriage officer will ask for solemnization. If he refuses to solemnize, either party to the marriage may file an appeal to district court. If district court will reject the objection, there is no remedy to approach an appellate court. Power of marriage officer in respect of inquiries. During inquiry, the marriage officer shall have all the powers vested in civil court under the Code of Civil Procedure 1908 regarding summoning and examination of witnesses, discovery and inspection, etc. If objection comes out to be unreasonable and not made in good faith, the marriage officer may award compensation to the extent of 1,000 rupees to the intending parties to marriage. It is to be realized from the person who files the objection. Declaration by parties and witnesses. Before the solemnization of marriage, both the parties shall file a declaration. The declaration must be signed by the parties and 3 witnesses in the presence of marriage officer. It shall be countersigned by the marriage officer. Place and form of solemnization. Marriage may be solemnized at the office of marriage officer or at such other place within a reasonable distance from his office. It may be solemnized in any form which the parties may choose to adopt. Yet it shall not be complete and binding on the parties unless each party says to the other in presence of marriage officer and 3 witnesses that I, A, take thee, B, to be my lawful wife or husband. Certificate of marriage. When the marriage has been solemnized, the marriage officer shall enter a certificate in a book called the Marriage Certificate Book. It shall be signed by the parties to the marriage and 3 witnesses. New notice. New notice is required when the marriage is not solemnized within 3 months of permission given by the marriage officer to solemnize the marriage. Registration of marriages celebrated in other forms. Section 15 to 18. This procedure of registration is to enable the spouse already married in any other form to have their marriage registered under this Act. These are the requirements. Number 1. Conditions of marriage. Certain conditions are to be fulfilled for the registration of already solemnized marriage under Section 15. Ceremonies of marriage must have been performed and they have been living together as husband and wife. Neither party has more than one spouse living at the time of registration. Neither party is idiot or lunatic. And parties have completed the age of 21 years at the time of registration. Parties are not within the degrees of prohibited relationship, except where any law, custom, or usage governing each of them permits the marriage between the two. The parties must have been residing within the district of the marriage officer from 30 days immediately before the application for the registration of the marriage. Number 2. Procedure for registration. 2 persons who want to get their already celebrated marriage registered under the Act have to follow the given procedure. Application to the marriage officer signed by both the parties. Public notice of that application by marriage officer. Any person can raise objection within 30 days against the intended registration. After hearing any objection received within that period, if the marriage officer is satisfied that conditions of Section 15 are fulfilled, he shall enter a certificate of marriage in Marriage Certificate Book. It shall be signed by the parties to the marriage and by 3 witnesses. Appeals from orders of refusal. Any person aggrieved by any order of refusal by marriage officer to register a marriage may file an appeal before district court within 30 days. Decision of district court shall be final. Effect of registration of marriage. Any marriage registered through this procedure shall have following effects. Number 1, marriage shall be deemed to be solemnized under this act. Number 2, children born after date of ceremony of marriage shall be deemed to be legitimate children of their parents, but it shall not confer upon such children any rights in the property of any person other than their parents, if otherwise they have been incapable of possessing such right. Number 3, matrimonial remedies. The Special Marriage Act 1954 provides, number 1, restitution of conjugal rights, section 22. Number 2, judicial separation, under section 23. Number 3, nullity of marriage, section 24 and 25. And number 4, divorce, section 27. Restitution of conjugal rights, section 22. This relief or restitution by a court decree is to preserve the marriage tie as far as possible by the intervention of court. These conditions are to be satisfied for obtaining such decree. The other spouse has withdrawn from the society of the petitioner. Respondent has no reasonable excuse for such withdrawal. The court's satisfaction as to the truth of the statements made in the petition. No legal ground exists for refusing the decree. Constitutional validity. Section 9 of the Hindu Marriage Act 1955 is a pari materia with section 22 of this act. So it would be relevant to discuss the constitutional validity of section 9, which has been challenged in T. Sarita versus T. Venkatasubaya. The Andhra Pradesh High Court held it to be violative of Article 21 of the Constitution of India. Shortly after this judgment, the Delhi High Court in Harvinder Kaur versus Harmander Singh and the Supreme Court in Saroj Rani versus Sudarshan Kumar upheld the constitutional validity of Section 9 of the Hindu Marriage Act 1955. Judicial separation, Section 23. Under this relief, a decree of separation does not put an end to the marriage. The legal status of the husband and wife subsists and they cannot remarry. The parties are only permitted to live separately. Grounds. Either party to the marriage can present a petition for decree of judicial separation on any of these grounds as specified. Under Section 27(1), voluntary sexual intercourse, desertion for 2 years, 7 years imprisonment, cruelty, unsound mind, suffering from venereal disease, suffering from leprosy, has not been heard alive for a period of 7 years under Section 27(1)(a). Husband guilty of rape, sodomy or bestiality. Cohabitation between the parties has not been resumed for 1 year after the decree or order of maintenance passed by court under Section 18 of the Hindu Adoption and Maintenance Act 1956 or in proceeding under Section 125 of the Code of Criminal Procedure 1973, and both parties are living apart since the passing of such decree or order. On the ground of failure to comply with a decree for restitution of conjugal rights, when the court grants a decree for judicial reparation, it shall be no longer obligatory for the petitioner to cohabit with the respondent, but parties are free to resume cohabitation as the doors for reapproachment are open. Nullity of marriage, Section 24 and 25. A marriage may be valid, void or voidable. Valid marriage is constituted when all the required conditions are fulfilled. Void marriage is void ab initio, that is, right from the beginning. It has no legal status and no rights and obligations ensue from this type of marriage. A voidable marriage is a binding and valid marriage until the decree of annulment has been passed by the court. Divorce, Section 27. Term divorce has been derived from the Latin word divortium, which means to turn aside or to separate. It is a legal end to the matrimonial bond. A civil marriage may be dissolved by a decree of court on any of the following grounds. Fault grounds of divorce, Section 27(1). These grounds are available to both the spouses. Either party may file petition for a decree of divorce on these grounds. Number 1. When respondent had voluntary sexual intercourse with some other person other than his or her spouse. Number 2. Desertion of petitioner for 2 years or more. Number 3. Imprisonment for 7 years or more to the respondent. Number 4. Cruelty by respondent. Number 5. Respondent is suffering from incurable unsoundness of mind. Number 6. Respondent is suffering from venereal disease in communicable form. Number 7. Respondent is suffering from leprosy, disease not having been contracted from the petitioner. And number 8. Respondent has not been heard alive for a period of 7 years or more. Wife's special grounds, Section 27(1)(a). These are the grounds exclusively for wife on which only she can file a petition for divorce. When husband is guilty of rape, sodomy or bestiality since the solemnization of marriage, if the parties have not resumed the cohabitation after the decree or order of maintenance passed by the court under Section 18 of the Hindu Adoption and Maintenance Act 1956 or under Section 125 of the Code of Criminal Procedure 1973, and since this decree or order she was living apart from the husband. Breakdown grounds, Section 27(2). These grounds are also available to both the spouses. Non-resumption of cohabitation between the parties for a period of 1 year after decree of judicial separation, or no restitution conjugal rights between the parties for 1 year after decree for restitution of conjugal rights. On any of these grounds, a civil marriage may be dissolved by the decree of court. Divorce by mutual consent, Section 28. If the parties are unable to pull on their marriage and they have agreed to break their marital ties, they can do so by divorce by mutual consent. This provision was present in the Act originally since its commencement. Under Hindu Marriage Act 1955, it was inserted in 1976. These are the conditions to be fulfilled by the parties. Substantive provision. Petition for divorce to the district court by both the parties together on the ground that they have been living separately for a period of 1 year or more. They have mutually agreed that marriage should be dissolved. Procedural aspect. Second motion by both the parties not earlier than 6 months from the date of presentation of petition and not later than 18 months. If the petition is not withdrawn in the meantime, satisfaction of the court after hearing the parties and after making required inquiry that the averments in the petition are true and marriage has been solemnized. Then court shall pass a decree declaring marriage to be dissolved. Bars to matrimonial reliefs. There are certain bars prescribed under the Act of 1954 which should not be present in the way of any matrimonial relief, like restriction on petitions for divorce during first 1 year after marriage, Section 29, absence of any other bar like connivance, condonation of delay, accessory to, force, fraud or undue influence, etc. under Section 34. Maintenance, Section 36 to 37. Maintenance means provision of food, clothing and lodging. In legal sense, it refers to the payment to the wife which a husband is under an obligation to pay either during the subsistence of the marriage or upon separation or divorce. Alimony pendithalite, Section 36. Where any proceeding for some matrimonial relief is pending before the court, then court can grant some expenses to the wife from husband if it appears to the district court that wife has no independent income sufficient for her support and expenses of the proceedings. On application of the wife, order the husband to pay to her the expenses of the proceeding and such weekly or monthly sum as court seems reasonable during the proceedings. This application shall, as far as possible, be disposed of within 60 days from the date of service of notice on husband. Permanent alimony and maintenance, Section 37. Any court exercising jurisdiction in any petition regarding matrimonial reliefs may grant permanent alimony and maintenance. These are the requirements of this provision. On application made to it by wife, at the time of passing any decree or at any subsequent time, court may pass this order, that husband shall secure to the wife for her maintenance and support such gross sum or monthly or periodical payment of money, if necessary, by a charge on the husband's property, for a term not exceeding her life. This order may be altered or cancelled in these cases: change of circumstances of either party, wife has remarried, or she is not leading a chaste life. The court may vary, modify, or rescind any such order at the instance of the husband. Custody of children, Section 38. Custody, maintenance, and education of minor children have been attached a paramount importance when the proceeding for any matrimonial relief are initiated and finally decided. Then the court has to make provision for custody, maintenance, and education of minor children. Custody means entrusting the minor in the hands of a person who would look into overall welfare of the minor. Court may pass interim orders during pendency and may make such provisions in the final decree as it may deem just and proper for children. It may be given to father, mother, or even to any other person who may take better care about the necessities of the children. Consequences of civil marriage, Section 19 to 21A. The special form of marriage under the Act of 1954 will have the following consequences. Effect of severance from undivided family where any party to the marriage is the member of such family who professes the Hindu, Buddhist, Sikh, or Jain religions, Section 19. Right and disabilities with regard to the right of succession to any property are not affected by the Act. Severance of family will be deemed by Section 19 and right of succession is preserved by Section 20. This section not only speaks of right of succession, but it also fastens the married persons with the liabilities which they have to discharge. For example, debts, taxes, and other religious liabilities towards the family. Succession to the property of any person whose marriage is solemnized under this Act and to the property of the issue of such marriage shall be governed by the Indian Succession Act 1925 and not by personal law of the parties. There is one exception to the application of the Indian Succession Act 1925 for succession. Where the parties to the marriage are persons who profess the Hindu, Buddhist, Sikh, or Jain religion, then Section 19 and 21 are not applicable. Succession to their property shall be in accordance with their personal law. With this, we come to the end of today's lecture. Hope you have enjoyed it and thank you for watching.